Hi, I'm Cian O'Carroll, and back in 2018 I met Vicky Phelan when she was looking for a solicitor to help her fight her case. She went on to win that case and uncovered a shocking healthcare scandal that has affected so many women and families across Ireland. We also became friends. Vicky went on to fight one campaign after another for women's healthcare in Ireland, and all the time fighting for her own life, fighting for more time. This is a series of conversations where Vicky and I discuss what went wrong in CervicalCheck, how those fatal and life-changing mistakes happened, and look at what Vicky has achieved since she became an advocate for change. Hello and welcome. I'm Cian O'Carroll, and once again I'm in conversation with Vicky Phelan. Good morning, Vicky.
Good morning, Cian.
Sun rising over the Potomac?
Yes, beautiful day here now, thank God. So I definitely plan on getting out for a nice long walk by the river as soon as we get done here.
Lovely. When we were last talking, we were talking about the CervicalCheck Tribunal. Mm-hmm. And the conversation we were having at that stage was sparked off by the recent reports that the tribunal has been spending what seems to be a vast amount of money in setting itself up in terms of buildings and facilities. €2.5 million spent already, and really very little interest from any of the people that the tribunal was supposedly set up to serve. And we had been talking around why that was and how poor the engagement was by the likes of Stephen Donnelly as Minister for Health and his predecessors. Indeed, how the tribunal itself had come about as a result of these really disappointing failed promises from Leo Varadkar in the wake of your case.
Yes.
And what we wanted to do today was to try and look at this in a little bit more detail with a little bit more structure. And for that reason, instead of having our more free-flowing discussion that we tend to have, and which perhaps drives people mad, we were going to have a more structured discussion based on a set of notes to try and keep us on the straight and narrow.
Yeah, I think it's important to do this today because I think a lot of people don't understand why we had so many issues with the tribunal. I remember, in fairness, most people were quite positive, but there was quite a lot of messages we got after we pulled out from the negotiations, from people wondering, why they just didn't understand why we couldn't reach some kind of an agreement. So I think it's very useful that we do this today.
And we're not going to get into the I was going to call it a negotiation, but it really wasn't. It was you guys in 221+ putting forward your concerns about the tribunal, and effectively Stephen Donnelly and the people who were running him saying nothing, saying either go to hell or we're not listening to you.
Yes, that was pretty much it.
At least that was my...
Yeah, no, but that's exactly how it felt for us too. I mean, obviously when you're in negotiations for anything, there is always a bit of toing and froing. But for us, there was no toing and froing. It was all very much, them dictating to us what the terms were going to be for this tribunal. And our voices and our needs were not being listened to or being heard or being met. There was absolutely there wasn't even a, meeting halfway. It was, every time we brought up an issue that was a concern for us, it was shot down pretty much straight away, to be quite honest.
So what we're going to try and do then now is to look at the three main reasons and the various points under each one, the three main reasons why the tribunal is of such limited use to the very small category of people for whom it allows applications, from whom it allows applications. So quickly, just to run through the three categories, or the three reasons rather, why we say the tribunal is of limited use. Firstly, most cases that are eligible for the tribunal have already been progressed in the High Court.
Absolutely.
That doesn't mean that they're finished, but they're going through that process. So they're now already in one process. They would need some pretty good reason to make them move to another process.
Exactly.
The second reason why it's a very limited use is that very few people are actually eligible out of the group of either 221 or RCOG. Even within that group, very few are actually eligible to bring their cases to the tribunal, and we'll explain that in more detail and really why that came about. And the third reason is that there is really very, very little difference between the tribunal and the High Court. Despite all of the blurb and spin that's been put on the tribunal by the likes of Stephen Donnelly and surrogates of his, when you look at it carefully as a lawyer, it is really indistinguishable from the existing High Court proceedings and procedures which are there, with one or two small differences which we'll look at, which have been trumped as being of major significance. But I think the women and families who were affected and for whom this tribunal was allegedly established for at enormous public expense, they are clearly not convinced, because so far, 5 months into a 9-month application period, there are 3 applications.
Yeah, that's pretty shocking, isn't it, to think that, here we are, 3 years later from when a tribunal was promised, and 5 months in, and there only have been 3 applications. So that tells you everything I think you need to know about, I think that the figures speak for themselves, really, don't they? I mean, it's not just us.
I think they do. I'm assuming that the Department of Health is going to come out, though, however, and say that people are misguided, and perhaps they're even being misguided and misdirected, and you're going to have all of this kind of blaming going on. But the clients certainly that we act for, and that we've been keeping them informed, and I know they've been informed separately by 221 Plus, that you're very closely involved with, they're not fools.
Exactly.
They're a very articulate, savvy cohort of people, and that has been evident from the very start. And we get a lot of questions, obviously, from people, but they know what they're on about, and they haven't been convinced. So I think really the minister has only himself to blame for that. Yes,
absolutely. And I think, we certainly would have informed our members when we were in the negotiation process with the minister and his department at every juncture. So we would have actually gotten feedback from our members about what they wanted from this tribunal. So it wasn't just me, Stephen Teap and Lorraine Walsh, rocking on up to this, these meetings and dictating what we wanted. It was what our members wanted. So, we polled them. We did a number of workshops, online workshops. We had somebody come in and talk to them to give them kind of independent advice on, the difference between a tribunal and a high court. So, there was a lot of information that was given to our members, and it was all factored in when we were in the negotiation process about what we wanted from this.
So looking then at things in a little bit more detail, the first of those issues is pretty easy to discuss, and that's, again, these are the reasons why the tribunal is so limited. The first one is that most cases that are eligible for the tribunal are already progressing in the High Court. So that's an easy one to discuss. And obviously the reason for that is that the tribunal itself is only open to people from within either the group of 221 women or families of women who had died, who were identified with having a discordant smear that had led to a significant delay in their diagnosis and the commencement of their treatment. That's the formula. Or somebody who was a member of a separate group, in addition to that being the RCOG review, which was conducted and reported on in November of 2019. And because of the operation of the statute of limitations, which is the law that sets a time limit on the time by which you have to make an application to court, the people who were informed of the discordance back in April and May of 2018 following your case, when the disclosure took place, or some people had been given disclosure before that, the time ran out for them to take a case. The 2 years ran out for them in most situations by May of 2020.
Yeah, exactly.
People who were informed of a discordance which may amount to negligence. Discordance does not. We keep on stressing the point, despite what certain branches of the media would like to suggest otherwise, or how they'd like to suggest otherwise. We are very conscious of the fact that not all discordances are occasions of negligence.
Negligence, yeah.
But discordance is what triggers the questioning. Was my discordance negligent? And for RCOG people, they were only typically informed of that in November of 2019, which means that they would have 2 years from that date, presumably, plus maybe some other arguments. So they would still have time to bring an application.
Yes, exactly. And this was a huge, one of the huge issues that we brought forward to Minister Donnelly at the time about the statute of limitations, because in most instances, for practically everybody in the 221 plus group, the statute of limitations ran out, by May 2020. And, we were having negotiations at this stage, well past May 2020. So what we wanted to assurances from the minister that anybody who was in that situation, who was waiting for a tribunal. So there were some of our members who were waiting in good faith for a tribunal to be established who did not issue proceedings, and they should not be excluded from being able to take a case because of a delay by our government in getting this tribunal established. And that was one thing, that one of our big asks that we wanted written into this this negotiation, that would be something that they would absolutely anybody in that situation would be able to take a case, and we could not get assurances from them on that point.
And we discussed in the last episode how that would have been achieved were it to be done. There were two simple statutory ways by which that could be done, but it was clearly the decision that it wasn't going to happen. And the issue then is that those individuals who clearly had suffered harm and had a right to legal redress had to issue their proceedings on or before April or May, depending, of last year, of 2020.
20, yeah.
And having done so, and many of them would have issued their proceedings well before that, it was only ones who were maybe holding out for the tribunal, and then decided at the end they had no alternative but to throw in their lot with the High Court process. Others would have brought High Court proceedings well before that, and then you're talking about the group who held out, still believed this line which was being peddled even after that date, that, the tribunal is coming and there won't be a problem about making applications to it. I think you had correspondence from the minister even saying that isn't a real issue.
Yes, we did.
And it certainly is a real issue, and it'll be a very real issue when the laboratories get their hands on it, because they're not going to be consenting to any redress being paid to somebody from their funds where that person is out of time or too late for bringing an application.
Exactly.
So but anyway, that's the first issue why the tribunal is of limited use to the group.
Okay.
Because they've already got proceedings. And
yes.
Why would they now break off and go with a new process? The second one is that very few people are actually eligible out of that group of 221/RCOG. So we don't know how many people that group is in total, but it seems to be something around 300 people, because they never gave us the split on exactly how many people were picked up in the RCOG review who hadn't already been picked up in the 221 review. But let's say it's 300 people. We then have to look to see, of that group of people, how many of those are actually eligible, because when they set out the criteria for eligibility for the tribunal, the people who set it out, I think they did it first of all having pretty much your case, the state of knowledge around the time of your case 3 years ago in mind. And they didn't ask people who were actually involved in building cases for the women affected, like us. Nobody asked us, what do you think? Even to have us in as part of a discussion, a dialogue.
Yeah.
To get a view on it. I appreciate we come to it with a certain bias. Our bias is to do the very best for the women affected. We are not interested in putting forward the rights beyond the ordinary legal right of representation for the laboratories or for the HSE. But we have a point of view that is valid, and it wasn't sought.
And you also have a point of view that is extremely valid in this case, because the tribunal is supposed to be for the members, so it is supposed to be for the women and the families affected. And who best placed to know what those members need than their solicitors, or solicitors who have already taken cases.
But Vicky, no, the tribunal was promised as something which would be for the women. What Leo Varadkar said was the state will stand with the women against the laboratories. He used the word for and he used the word against.
Yeah.
That is not what happened. And this tribunal is like a high court. It is identical to the high court in almost all respects. And that means that it cannot be for any party. It is precisely in the middle. It is justice holding up the scales, and they're evenly balanced. So there's no bias in favour of a plaintiff here. And I have no difficulty with that, because that's the environment that I'm used to bringing cases for clients in. But that is not the impression that they've continued to try to give. They've tried to create the impression that this is some sort of compensation tribunal where you apply and we will work out what the appropriate damages should be given the suffering you've gone through. And that's a lie. And to be fair, naturally, the judges involved in this have made that very clear in their statements, that this is not a non-adversarial tribunal. This is just as adversarial as the High Court. High Court isn't always rip your guts out, rip your throat out kind of adversarial. It's not like that. But you do have to fight your case. So it brings us then to this point of looking to see, well, who then from that group of, say, 300 people or their families, who is included? Or who is perhaps excluded, I should say. So first off, if you have a case which is being brought with a spouse involved, you can't bring it to the tribunal. Now that might sound like, oh, sure, how many of those are there? Well, there was one famous case of Vicky and Jim Phelan.
Yeah.
How about Ruth and Paul Morrissey?
Yeah.
Quite a high percentage of the cases, and particularly almost all cases where there is serious harm involved, will have spouses involved.
Yeah.
And that is because there is, and the High Court has acknowledged, that there is a loss to the spouse, because the injuries involved here are so destructive of the intimate relationship and the sex life between a loving couple. And that is one aspect of the loss. There's the psychological and just relationship harm that does, which is another part. Although those psychiatric damages the High Court has not gone with, but it has gone with this idea of loss of consortium, which is the loss of the intimacy. And damages are recoverable for that, and so that case needs to be brought for the spouse. All of those cases are excluded from the tribunal.
Yes, I know.
Nobody asked.
No. But I mean, if they were using my example as a test case, for the basis of this tribunal, I mean, they could see that the case that I took was, as a named plaintiff in conjunction with my husband, and my husband was named. So why would they not follow that pattern and include spouses? I mean, it makes absolutely no sense.
It's bonkers that you would say, what? If Vicky Phelan's case was starting today, she couldn't go to the tribunal.
Yeah.
That's the truth. Yeah.
Yeah.
The next issue, the next group of people who can't go, nobody who was diagnosed with cervical cancer after, say, December 2017 and has gone back and had a look at their smears can apply, because they weren't audited. They couldn't have been part of the 221 group or the RCOG group. So you have this huge cohort of people over the last 3.5 years now who aren't entitled, and they have to go to the High Court. And we've seen, the late Patricia Carrick, just such a case. There were other cases that have come before the courts already because they were very urgent, which all apply to that. And cases more recently, which we haven't been involved in because other people's cases have been coming through, have been in that category. So really, any case that you've ever heard of isn't entitled to go to the tribunal.
Yeah, I mean, that's crazy.
Okay,
Yeah,
that's as bad as it gets, right?
God.
The next category is in fatal cases where there are dependent children. Now, this happens quite often, and if you're to take the example, and again, I try to avoid naming too many cases, but certain cases are out there in the public domain and people are aware of them and they're being reported on. But the late Vicky Phelan, it was necessary at the understandable request of the defendant, their Quest Diagnostics, who admitted, just for all the naysayers, in that case, Quest Diagnostics shockingly admitted to negligently misreading 2 of her smears, causing her death. They acknowledged that, admitted it, apologised for the resulting loss of her life that was at that time yet to happen. They insisted that her children be made co-plaintiffs in the case so that their interests will be protected on the road. In other words, that everything, all of the consequential loss to that family would be encapsulated in that case and no further case could be brought in the future.
Okay.
That requirement meant that that case couldn't have gone to the tribunal either, because the tribunal expressly states that where the woman is alive, only she can bring a case, and a family can only bring proceedings in circumstances where she has died, not where she will die.
Okay, right.
So that's another situation, albeit perhaps a less common one. And then the biggest one of all, the fourth and final category that I would identify here, which is where any cytology issues relate to other slides. So the tribunal only applies to issues of negligence that relate to slides which formed part of the CervicalCheck program.
Yeah. And is it just to slides that formed part of the audit? That, as you know, apart from the fact that it only applied to slides that pertained to the CervicalCheck program, was it specific to slides that were identified in the audit and any other slides were not to be included? Is that what that means?
Well, I hesitate because I'm trying to think of an example where that would arise. No, I think once the slides were, once the discordance occurred within the CervicalCheck program, it can be admitted to the tribunal. What I can't think of is a situation where there was a slide within the CervicalCheck program that wasn't audited. But that could have happened. In other words, where they overlooked one that they were looking at. What is a very common situation, however, is that, and indeed it happened with you, you had a smear from 2007, for example.
Yes, before the CervicalCheck program was established, prior to...
Precisely. Now, if that slide had been discordantly read, it could not have, your case could not have been considered in the tribunal unless you decided that you were going to abandon that issue and not bring forward that argument. But even if you abandoned it, the laboratories would bring it in as a third-party issue because they would say, well, why would we carry the can completely when somebody else made a mistake in 2007 or 2006 or 2005 or 2004? And we see in every case now that they're scrutinising the entire screening history of each person, going right back well before the tribunal. And frequently we are finding discordances among those, which then mean that that argument is solely against the HSE, but it takes it outside the tribunal. The same would apply if you found a GP issue, where the woman may have gone, for example, complaining of intramenstrual or postcoital bleeding, pain on intercourse, and perhaps on a physical examination, something might have been even noticed on the cervix. But a smear was taken instead of a referral to gynecology. We've seen that on a number of occasions, and that would be something which would be criticised in. I don't want to get into generalities because it's it isn't fair, but I think that can be criticised in certain situations. It forms part of a case that's outside of the tribunal. Any issues that relate to gynecology referrals or colposcopy outside of that which is identified in RCOG is also outside the tribunal. But we're seeing that in about a third of cases.
That's a lot. That's a lot of cases.
And the analysis and investigation of cases has become so much more complicated since your case. It's just a different world. And obviously the stakes are so high that laboratories are applying very significant resources. Meanwhile, the state takes this neutrality position, so they don't get involved. They don't even investigate slides. They don't even investigate laboratories, of course, as we know, which is a big part of the problem. Even to go back to Emma Vicky Phelan's case, 2 slides, they stood up in court and they admitted that these mistakes cost this woman her life, and that still didn't merit an investigation of those slides being triggered in the laboratory by the National Screening Service.
Yeah.
So how is quality assurance supposed to be maintained if even that doesn't merit?
And that the fact that Quest is now performing 90% of the smears of all women in Ireland, aren't they? Still,
Absolutely.
You would think at the very least that they would investigate.
But what did Dr. Jerome Coffey say in his memo to the Minister for Health in your case the week before your trial started? He was quoted in a memo to the Minister saying
that my case was not a patient safety incident. Isn't that exactly what he said?
Precisely. Yeah. Not a patient safety incident.
Yeah.
Nothing to look at here, lads. This is fine. This is just
pretty shocking, isn't it? Yeah.
So with that mentality all the way through the system, anyway, we're getting off the point. And the point is, why is the tribunal of such limited use to the people that it was meant to be of tailored,
exactly,
bespoke use to? So they're the reasons why you can't get into the tribunal, even if you're one of the 221 or COG groups. And there are people obviously within that who are.
Yeah. And I mean, one of the very high profile case that just settled recently was Lindsay Bennett. And Lindsay Bennett, was interviewed on the Late Late Show and said that, she Ryan Tumbley asked her why she wasn't applying to the tribunal, because obviously it was set up at that stage by the time her case came around, and she said it was because she wasn't eligible. And obviously it comes down to the fact that she has 2 dependent children, I would imagine, based on the categories that you've just outlined there. Would that be what you think?
Right,
yeah.
That would certainly be one issue that could well have arisen. I don't act for Ms. Bennett, and so I'm not in a position. It's better not to comment, I suppose. But
I just think it's useful to use her case as an example, because everybody would have seen her, and the tribunal had been established by the time her case got into court. So people would have been asking, I'm sure, well, why isn't she applying to the tribunal? And your categories there have, she obviously fell into one of those categories, and she said that her solicitor did apply to the tribunal and was told that she was not eligible. So here we have a tribunal set up.
That's interesting, but I there are 2 other issues that would have jumped out at me there. First of all is that her proceedings, as I understood it, began in 2020.
Yeah, January
just
2020.
From news reports. Was it January of 2020?
Yes.
There was also a high level of urgency in her case.
There was, at the time, yeah.
And I should have included in that list, if you have an urgent case, you can't go to the tribunal. The tribunal cannot possibly compete with the speed with which the High Court can deal with the case.
Wow.
The tribunal has very fixed time limits. And while on the face of it, if you add up all those time limits, it looks like you could get a case through the tribunal in 9 months or something. We'll come to this in a second, but it could if the laboratories were playing ball.
Yes,
They haven't played ball so far, so I don't see why. There's only one reason they're going to play ball, and that's because they like it. And they're going to like it because of only one reason. They feel they're going to have to pay out less money.
Yes.
That's my understanding of that. But that's down to the awards that are made by the tribunal. And by the time we get to any awards, the doors will have been closed, the shutters will have come down on admissions to the tribunal. So everyone has to be in before they'll make any awards, as far as I can see. That's pretty worrying.
Okay. That is pretty worrying, yeah.
I wouldn't like to be advising
who's going to take their chances? Exactly, who's going to take their chances on that?
Any guinea pigs, please? Well, where you've already got clients within a system, within the High Court, and you've good experience and know how that's going to work and how it's going to progress, it does make it difficult to invite somebody to take a chance on something new. However, there are still situations where I do think it is suitable and we have or will be recommending it still to certain people. So I wouldn't like for a moment to suggest that I think this is an utterly worthless proposition. The point is that it is so far from what was promised, and it is so far from what is needed by the people that we've heard so much lip service about, but it is purely lip service.
Yeah, exactly. Yeah, and I mean, that's what we would have advised our members at the end when we did, remove ourselves from the negotiations and withdrew from the negotiations. We advised our members that, we felt that it was up to them to make the decision ultimately on whether or not they wanted to apply to the tribunal. But we gave them all of the information as to why we didn't think it was suitable, and why we, withdrew from the negotiations at the end of the day and could not stand over this tribunal. But, at the end of the day, there will be a certain number of people who will apply to the tribunal. And, one category of people I think that will probably apply to the tribunal are those people, and you can correct me here if I'm wrong, who only have a claim as far as non-disclosure is concerned, where there may not be negligence. So they wouldn't have a case to be heard in the High Court. Is that correct?
Well, that is certainly a group, all right. The difficulty with a non-disclosure on its own case, I wonder how many of those there are, because non-disclosure in the High Court has been measured at €10,000 in terms of redress. And yet the ex gratia scheme that was established allowed for €20,000 by way of redress. So if I had a client who had found that even though they had a discordance, which had been picked up on the audit, and the audit hadn't been disclosed to them, now you go back and you look at that slide and you say, well, right, was that discordance at the level of negligence, of a breach of duty? You get an expert report back that says, no, it wasn't. You're telling your client, right, you don't have a cause of action in respect of going on to develop an invasive cancer, but you still have your non-disclosure. I'd be saying to them, you should be going to accept the ex gratia payment of €20,000, because in the Morrissey case, the High Court calculated the value of those damages at €10,000.
Okay, so you would get.
But you are correct to say that case could go to the tribunal, but you would imagine the tribunal would be guided by the precedent of damages established in the Morrissey case. They wouldn't be bound by it, but you'd be taking a fair old gamble to say that you would go through all of that expense of effectively a High Court case for damages that could potentially be as low as €10,000.
Yeah, okay.
This is still all the work and all of the risk of a High Court action in terms of legal costs.
Yes, because that's what people, I suppose, are maybe not getting, that it still costs the same to take a case to the tribunal. It's not any cheaper because you have all of the same parties involved and all of the same costs. And if you're not
successful.
Yeah.
And if you're not successful, or, you can be successful in a case and still be unsuccessful by not meeting a certain threshold of damages.
Okay.
And if that happens to you, an award of costs can and will be made against you.
And that could be far higher than what you actually have been awarded. Yeah.
You're handling a very volatile substance when you're taking litigation. It is not to be.
Well, it's not for the faint-hearted
casually.
Anyway. So it's not.
And it's not for the faint-hearted either, I suppose. I mean, I wouldn't like to talk up too much how difficult. You're the best person to talk about that, about what it feels like, because I do it for a living. So
yes. Yeah, I found it quite intimidating, I have to say, and I have spoken about this on a number of occasions. And I was actually invited to the Bar of Ireland to talk about my experience as a plaintiff. And, I was quite honest about that. Like simple things like the layout of the court, for example. People don't understand the way, I certainly didn't, understand that when I went in that I wouldn't be able to see anybody. So you're you're at the side. And you're facing the judge, the judge is facing down at the top, obviously looking down over everybody else. It's very hierarchical. So there was a stenographer literally sitting across from me, my little table. Literally she was, it certainly wouldn't happen now with COVID, there was barely a desk between us. And I could see the judge, from my angle, but I couldn't see anybody else. All the solicitors and barristers, including yourself, I could see the backs of your heads, but that was as much. And that threw me, I have to say, the first day that I was there, it really threw me because I didn't realize that was the way the room was going to be set up. You know, I thought everybody would be, not necessarily around the table, but I thought I would be able to see people, and I couldn't. You know, once I kind of got over the initial shock, I think I was fine, but it's definitely intimidating.
Well, to be fair, Vicky, you'd have to say that having spent 1.64 million euros in doing up the new offices for the tribunal, you'd have to assume that they have a better setup than that.
Yes,
So maybe
you would hope so.
That's an advantage. You would, yeah.
But is it
And
worth
maybe
that money?
you'd be able to see more than the back of my head. I don't know. We'll find out. But in terms of facilities, and I have been facetious about this so far, but with all sincerity, I mean, great if they've designed a courtroom that is far better, but that's really not enough, I think, to hook people in. Now, what you were saying there, and your discussion before the Bar of Ireland as well, we've talked about that before, and we'll probably talk about it again. But just to keep us on this list of notes, this is why we made notes, to stop us from
going off on a tangent, which we are very
our
prone to do.
Ramble.
Yeah, exactly.
Yeah, but we wend our way through it.
We do.
Is the third point, the third topic, our heading of why is it not of sufficient use to be attractive to most people? And that is that there is very little difference between this, what's being called a tribunal, and the High Court, contrary to what the Taoiseach and the Minister for Health claim. Now, this was brought into focus for me on the day when Patricia Carrick had died and the Taoiseach came into the Dáil to make an apology.
Yes, I remember that day well.
And in the questioning of him by leaders following that, there was a telling discussion where it was put to him that the tribunal was not adequate, and what was being mooted was not, well, it was being set up at that stage, it was kind of being finalised, wasn't right. And the Taoiseach said, with complete sincerity, he said, no, this is a tribunal. You don't understand. I was involved in the hepatitis C tribunal, he said. And I can tell you that it is a tribunal just like that, where people will go in and their injury will be listened to and they will have damages assessed. And you go, this is the Taoiseach of Ireland.
Yeah.
He hasn't a clue. He actually thought it was a compensation tribunal, just because somebody stuck the name tribunal on it.
Yeah.
And the reason that was the wake-up moment for me was that I said, well, if he can't get it,
yes, how can everybody else? Exactly.
So everybody's going to be kind of, in a sense, fooled by this tag of tribunal. A tribunal, a place where a decision is made. A court is a tribunal. I'm not criticising the concept of a tribunal. But to associate it with other tribunals that have been held in the past, which were compensation tribunals, where somebody didn't have to prove the wrongdoing or be put into a confrontation with these third parties, these non-state entities, private multinational conglomerates. That's so misleading and so wrong.
Absolutely.
So what is the difference then here? Well, I've just made a list of 5 different areas. I mean, the first one, the rules and the practice and procedure.
Exactly the same.
It says in the Act, it shall be in accordance with the High Court. Second one, the calculation of damages or compensation or redress, whatever you want to call it, whether that's the pain and suffering aspect or the quantification of your losses in terms of nursing care, end-of-life care, perhaps loss of earnings, all of those different things, identical.
Okay.
Third one, privacy. A lot has been made of this, that, you know, women won't have to be exposed to publicity and they can go to the tribunal. Well, the only people who were exposed to publicity, if you can use that word, the only people whose names became known in the High Court were people who wanted their name to be known for a bloody good reason, which is because they wanted a bit of light shone on what was going on. And the first one of those was you.
Yeah, exactly. Yeah, I mean, I could have
But
remained
you chose
anonymous.
that.
Exactly, I chose
Yeah.
that, and we had a discussion about it, I remember. And, it was only, the main reason we decided that I go public was because we knew there were, other women involved, and we wanted to highlight the fact that this was something that was bigger than me, and that people needed to know about this. And we were very adamant, and I certainly was very adamant on that point. And Ruth, I remember having this conversation with Ruth Morrissey. I mean, she didn't want to go public. Do you remember? I mean, at the time, at the start of the...
She wasn't
Yeah.
public.
Yeah.
Her case was M versus HSE Medlab Inquest.
Yeah.
And it remained M all through the pre-trial applications, and it was on that final day, and it was because of Leo Varadkar. It was because of Leo Varadkar. She said, he promised me that I wouldn't have to do this.
Yeah. And that's what drove her to go public as well. So again,
She said that's it.
Exactly.
She didn't want that.
No, and nobody would want that. And in fairness, I have to say, I remember watching Ruth when she was, in court. She had the hardest battle really of all of us, because she was so very ill as well at the same time, and the court case went on for so very long. I mean, as far as I'm aware, I think you said it before, it was the longest running, or it still is the longest running medical negligence case, isn't it, in the history of the country? Am I right?
Longest running trial, yeah.
Yeah.
Longest running medical negligence trial.
And, bearing in mind she was a terminally ill woman. I mean, it's horrendous when you see that.
I know. And it doesn't matter that she didn't have to be there every day. It was constantly hanging over her, and it was like, why? Anyway, of all the cases they could have picked, there were other test cases that could have been picked. And they picked that one because they thought they could win it.
Yeah. Okay.
And they didn't, nobody had a fig of a concern for what that was doing to a woman who was dying or her family. No. And that extends to the HSE and the state. They could have stopped it. Everyone could have stopped it. I mean, they were bloody well able to stop Emma Vic Fahuna's trial when they knew how much damage she could do to them. Reputational damage. Emma had a power in the way she directed her message.
Yeah.
And it was so disruptive.
Yes.
In the sense of, it wasn't normal. It wasn't, she cut through so much fog and could say things in a sentence that would get right to the heart of the matter.
Yeah.
And for some reason that did cause quite a concern on Merrion Street.
Well, I think it was also the fact that she was a young woman with very young children, and I think it was her interview on Morning Ireland that really, everybody in the country, I think, listened to that interview, and nobody could have listened to that interview and not have had tears at what that woman was going through and what her children were going to have to go through, losing their mother at such a young age, so.
That was just a couple of days after your case. I was up in the Four Courts and I had been contacted. Actually, I'd been contacted by her, and then I was contacted by somebody else on her behalf. And I hadn't heard Morning Ireland, and I was just told, you need to listen to that interview.
Yeah.
And anyway, it was very upsetting. So...
But going back to the issue of privacy, as you said, you have had cases where women or their families have remained anonymous, and that is
completely
in
but
the High Court.
Most cases are, absolutely. And, for some reason, an awful lot of these surnames begin with M. So lots of M cases, K case. It's pretty common.
So there is no difference
of a certain rule. It is a special rule. It is a special limitation on the reporting of cases. It's not like anybody can just go into the court and say, I don't want publicity around my case. That doesn't work. But in circumstances where you're having ongoing medical care and there's a concern that publicity will affect that in some way, well then, under a particular provision, the judge can make an order, and that has been granted in any case we've looked for cases of this nature. Okay. But like I say, if you have an accident in the workplace and you go in, you're probably not likely to be to be given that level privacy. So all I'm saying is that the tribunal isn't about privacy. The tribunal is about secrecy, in the sense that it was set up so that nobody would ever find out what was going on in there, except in certain circumstances. And that's what suits the laboratory.
Yeah.
So people want perhaps privacy, but they want the world to know at the same time what's going on.
Yes.
The laboratories and the HSE want a lid on this, and nobody to find out what's going on and how many women are affected. And that's what the tribunal offers.
Yeah. Yes.
But there may be situations where those two desires meet. And the fourth issue is liability and causation issues. How are they dealt with in the tribunal? Well, liability is who's at fault, and causation is what damage flowed from that mistake that perhaps wouldn't have happened anyway, or from some other cause. And very often you've got situations where fault can even be admitted, the who's at fault bit. But causation becomes the battleground in medical negligence cases. What exactly flowed from that mistake that wouldn't have happened anyway? How much of that is due to an underlying condition? And those have to be teased out. Those are all dealt with exactly the same way in the tribunal as in the High Court.
Yeah, there's no
You've
difference.
got to prove everything. No difference. You've got to call your experts. You've got to have those experts exposed to cross-examination by the defendant, and if there are third parties involved, certainly so far, they have looked from the High Court to be allowed for the third parties, being potentially laboratories, to also cross-examine the plaintiff's witnesses, and that would be the way that would proceed.
Okay.
And then finally then, to date, the labs how have they conducted themselves? So how have things run in the High Court that might give us some idea of how they would run in the tribunal? Now, the tribunal has time limits that allow gaps between different steps, but it doesn't have a maximum time limit. So it doesn't have a system that says, if you apply on day 1, it must be decided by day 365.
Okay.
It doesn't say that. So things will happen in the course of a case where another party will say, well, I want discovery of this, or I want access to this. I'm not happy, I'm not ready yet. And courts have an obligation to be fair and just to all parties. And they try and balance that against the need to push things on. So when you have a case like yours and it's urgent, well then the court will say, well, actually the balance is tipped in favour of the plaintiff here, and we're going to require certain steps to happen really quickly. And I don't care if that puts you under pressure. In less urgent cases, there isn't that balancing, and instead it's, well, as long as the cause of the delay is reasonable, they will allow it to happen. And that has been causing laboratories going in repeatedly saying they want this or they want that, or objecting to our applications for trial dates in non-urgent cases, has led those cases to be delayed.
Okay.
And I'm sure you could find reasons that you could blame us for the delay as well. You know, I mean, if I was a defendant solicitor watching this, I'd be saying, oh, that's very self-serving. He's forgetting about the fact that they only gave us, 6 months of records instead of 9 months of records in some case or whatever. I'm sure there are situations where we've been responsible for delay as well, but not very much.
Yeah.
And in general, the laboratories have been, I would say, actively resisting the orderly progression of cases.
Okay.
And I don't see why they would be any different
In
the
a tribunal. Okay.
So if you've spent a year and a half or 2 years progressing your case through the courts, and we're now at a position where we're close to being able to look for a date, I'd have to be advising somebody that if you kick that off and you move into a new process with all of those time limits and everything involved in it, that you're going to get your case heard faster. I'd need to be convinced.
Yes.
And then how much faster would it be to make it worthwhile? Even if you did come within all of the other issues that we've raised. So you put all that together and you say, little wonder they have 3 applications to date.
We put so much time and so much, I mean, we spent weeks on this, and we spent hours, as you did, trying to make our case heard, and just to see that it wasn't, and our needs were not being met. It was so, honestly, it's one of the things that has happened over the last 3 years that really upset me, I have to say. By the time we had to withdraw from negotiations, it really upset me, because I really thought that it was something that we could get for the rest of the women and families coming behind me, where they wouldn't have to go through that ordeal that I had to go through and Ruth had to go through. And it just didn't
The only
happen,
person I saw who had, sorry,
No, go ahead.
The only person I saw who had a commitment as well when this legislation was going through the Oireachtas, and I put a lot of work into working out, and my colleagues here in the office, into reading that legislation, that draft legislation, trying to work out amendments that could make it better.
Yeah.
And Alan Kelly was the only person who wanted to hear that, and he looked for suggestions, and then he teased them out with us, and he got an understanding of them, and then he went in and he put down those debates. Now, it was guillotine debate, so the whole thing had to be rushed through, and most of those amendments, there were one or two that were accepted, and most of them were rejected out of hand by Fine Gael TDs in the Joint Health Committee. And they were rejected out of hand, and we've discussed it before here, particularly the idea of having a facility for people to come back if their condition recurred and they were in trouble, having already settled their case. That was rejected with false information, ignorance, and possibly worse, by arguing that it was impossible for medical science to know when somebody had a secondary cancer that was related to their cervix, and that you could be compensating women who were like fakers coming in with breast cancers or some other type of cancer. I mean, it was extraordinary.
Yeah. It was extraordinary, because we all know, and I mean, there were some doctors. There was a GP, I think, and a pharmacist on that Joint Health Committee, weren't they?
The chair of the committee was Dr. Harty, who wasn't re-elected, or perhaps didn't run the last time, although he was at the Oireachtas golf function in Mayo last year. But that's not to say anything against the man for being interested in golf. But he was chairing that committee meeting as a GP. I would have thought he would have known that the first thing that happens, like, what happens when you get a recurrence of cancer, Vicky Phelan?
You're now considered incurable. I mean, that's what happens. And I've spent the last 3 years of my life trying to buy time, and that's all you can do is buy time, because you're not going to.
But because that's such a big deal,
it is.
But because that's such a big deal, they go and they test the cancer that has recurred to find out, is it a new cancer that we could treat, or is it a recurrence of the old cancer, which is now a secondary? Because if it is, it's curtains.
Exactly, and it's something that's very easily done, and it's something that they do routinely to confirm for themselves that it is a recurrence of the same cancer, or if it's a new one, because it makes a difference as far as your treatment program. So if it's a new cancer, there may be other drugs they can throw at it, but if it's a recurrence, well, not so much. So that is something that is very easily solved with a biopsy. So that that argument.
So Fine Gael TDs to use that as an excuse for not facilitating women who have recurrence of cancer in the tribunal, shame on you.
Yeah, absolutely. Yeah, I have to say that I remember watching that back, and I was just so disappointed to see. And particularly, I mean, whatever about, politicians who don't know any better, who don't have a medical background. There were two people on that committee who both had a medical background, and, voted
Kate
against
O'Connell
it.
was on it as well. She's a pharmacist.
Yes, absolutely. So they should have known better. I'm sorry.
Bernard Durkin also spoke for Fine Gael, but I don't think he has a medical background.
So if a woman takes her case to the courts, she knows there will be a finality to the decision, and she suffers a reoccurrence later on. That's it. That's the court system. She won't be compensated. That's unavoidable. But it's not unavoidable in a tribunal, and we have precedent for it. So we have a statutory provision being made for a new type of form, i.e. the tribunal, one operating to the practice and procedure of the High Court, yet free to make its own rules. So it provides for the cross-examining of witnesses and a whole range of other things. But why then can it not provide, as the Hep C tribunal, for all awards to be made as an interim award? So that if a reoccurrence happens, that the woman can return. Because unfortunately, in this scenario, there are going to be those cases, and they will be locked out of going back and seeking damages, whereby in some cases, unfortunately, the health outcomes may have deteriorated significantly. Thank you.
Thank you, Deputy Kelly.
Can I address the same one?
Yes, Deputy Smith.
In amendment number 14, I think this is really important because anybody familiar with anybody who suffered from cancer, the return of the cancer can be absolutely much more distressing and much more dangerous than the original case. And if we don't allow for that, then I think that's really punitive. And there is a likelihood in certain cases that it will return later on. And what do women do if they find themselves in those circumstances without the means, the financial means, the physical means, the support mechanisms around them to deal with the stress, which is double, treble what they originally felt? And I think we do have to allow them to return to the tribunal to receive the protection and the support of the tribunal and therefore of the state. I think to do otherwise would be really punitive. And as Deputy Kelly has said, it was allowed for in the Hep C case, and all you have to do is copy and paste what was allowed for there and insert it here, which is what we've done.
Deputy O'Connell.
Yeah, just briefly, maybe someone could give us advice on this. I would have thought it was complicated to link a representation of cancer later in life specifically to an incident 10 years previously. I'm just, like, where does the line get drawn? Otherwise the tribunal could go on for 100 years or whatever, maybe 60 years. So I think the Hep C is slightly different in terms of the infection and transmission is very much quantifiable and identifiable from the point of the infection of blood. I'm not an expert in this, but a small amount of information. So it would be very, very difficult to connect a cancer occurring 10 years after you have the all clear or whatever. Thank you.
Deputy Durkin.
Yeah, this could be a difficult situation, Mr. Chairman. On the one hand, it's readily recognisable that a person who has had cancer and has been diagnosed as having cancer and obviously cured of the difficulty, that it comes back subsequently in years at some later stage, and the extent to which you can identify it as a continuation of the previous condition.
Yeah.
Yeah.
But, you know, it doesn't matter. If you are on a joint health committee that is deciding on important legislation for the benefit of the women of Ireland and their families.
Educate yourself.
Precisely.
Exactly.
If you're dumb, get off it. Or educate yourself. Or
Absolutely.
ask somebody who does know.
Yeah.
Although it is disappointing that the chairperson of that committee on that day made no comment about that significant medical issue.
Yeah.
So be it. Vicky, we have tried to tease out what the details of the issues are. I'm sure there are other reasons or points there that we could have discussed, but overall, I'm very grateful to you for teasing that out with me and giving it your unique perspective.
Well, you know, I think it's useful for people to hear this from the point of view of a woman who has been through the court system and who has also been on the panel negotiating the terms of the tribunal, and then from a solicitor who has, you know, lots of experience of taking cases in a high court for a number of women, and particularly a number of high-profile cases, you know, and Ruth Morrissey's in particular, where, you know, the Supreme Court ruled, you know, made a number of rulings that should make a huge difference, but really we're still none the wiser, I think, unfortunately. So this tribunal really hasn't been, you know, what it could have been. No. Basically, it's very, very
a missed opportunity.
Yeah, absolutely.
And when you mentioned there about Ruth Morrissey's case, I think we should have, again, it's probably something that falls more into my area of things. So we don't want to have a situation where it's me doing all the talking, but we do certainly need to have an analysis in these conversations about the High Court and Supreme Court judgments in Ruth and Paul Morrissey's landmark case, a testament to both of their tremendous, just their bravery and their courage and perseverance in pushing through with that at such an awfully dark time in their lives.
Yeah.
And we'll come to that another day. But for now,
Yeah.
I'd like to thank you again for joining me in conversation, Vicky Phelan.
Thank you very much, Cian. Look forward to the next one.
Hi. Vicky and I hope that you've enjoyed that episode and you're finding the series informative. If there's anything else that you'd like us to discuss or touch upon, please mention it in a comment below. And to be informed of future episodes, hit the subscribe button.